Hi, this is Brian Ka with another video to help you pass the California Baby Bar and the bar exam. So we're going to do another wills and trusts question, and this is going to be from February of 2017, and this is question 1. So let's see what the call of the question is. What rights, if any, do Amy, Bob, and John have in whose estate? Um, Mary's estate. This is so we're trying to see how much Amy and Bob and John gets from Mary's estate here, right? So let's read the fact pattern. Mary was a widow with 2 adult children, Amy and Bob. In 2010, Mary bought Gamma and Delta stock. She then sat at her computer and typed the following: "This is my will. I leave the house to Amy and my stock to Bob. The rest they can split." Okay, so she sat at a computer. So this is an attested will, right? Because uh, she sat at a computer and typed, and the word typed is a trigger word indicating that this is an attested will. Now, before going further into the fact pattern, let's talk about what constitutes as a valid attested will. We've done this many times already. So, a valid attested will requires first intent, right? Second, it requires capacity and will formalities. Um, when it comes to capacity, we talk about usually whether the testator knows her bounty, the nature of her bounty, nature of her assets, and nature of her own actions. Also, for capacity, you have to be over 18, plus 18. So I hope you have this memorized now. This should come to you automatically. Now, formality is a little bit difficult because you have to memorize a bunch of stuff, but mainly it needs to be signed, dated, and in writing, right? Now, it needs to be witnessed by 2 disinterested witnesses. Disinterested meaning the witnesses can't be beneficiaries at the same time, or you're going to have to overcome the presumption of undue influence. So, third, witnessed by 2 interested parties, witnesses. The disinterested witnesses must sign um, before testator's death, right? Lastly, the testator must sign uh, with 2 witnesses present or acknowledge the signing with 2 witnesses present. Acknowledge or sign. Right? Acknowledge the sign or sign in front of them. This was tested in the other previous wills and trusts essay. So knowing that there's another option here is, I believe, very important. So we went through what is required in a valid attested will. We went through intent, capacity, formalities. We went through the elements of formalities. We also went through the elements of capacity. So okay. So we're talking about a 2010 will, right? I hope you can see that. Okay. So what happened? She typed, right? She typed, and Mary printed 2 copies of the document. She signed and dated both copies in the presence of her best friend Carol and her neighbor. So for 2010, signed, dated, writing, this is satisfied. Um, she signed and dated both copies in the presence of her best friend Carol and her neighbor Ned. So she signed to, while with 2 witnesses present. This also satisfies this element. Now, Carol had been fully advised of the contents and signed both copies. So, okay, the disinterested witnesses must sign uh, prior to the testator's death, right? So um, here, let's say half, because this is only talking about 1 witness. Although Ned had no idea as to the bequests, he declared that he was honored to be a witness and signed his name under Mary's and Carol's signatures on both sides. Huh. Okay, so we kind of have an issue of um, whether the witnesses must understand that they are signing an executory instrument, right? And I guess this is something that is brought up in the fact pattern. So I would argue both sides and say um, one side is going to argue, um, it's not necessary that the witnesses completely understand what is inside the testamentary instrument versus uh, the witnesses must know that what they're signing is a testamentary instrument, right? Here, um, the facts say that the witness, Ned, declared that he was honored to be a witness and signed his name under Mary's and Carol's signature on both copies. Okay, so he knew that he was being a witness, right? And it seems to me that um, arguing that dissatisfied the witness signing requirement and that they don't have to specifically know what's inside of it as long as they know that they're signing a testamentary instrument should be enough. I think arguing that would make this easy, because I think that if you decide to go the other route, then maybe I have a feeling that this essay is going to be more complicated, right? So it seems to me that that issue has to be brought up and argued on both sides. But in the end, I would conclude by saying that that 2001 will was a valid will. Okay. Now, let's see. In 2014, moving 4 years ahead, she soon decided to prepare a new will. She deleted the old document from her computer and tore up 1 copy, but she forgot, however, about the other copy in her safe deposit box. Okay, so as soon as you see deletion of her old document from her computer, tearing up, that calls for a will revocation, right? In the previous video, we covered trust revocation, where the language of the trust controls how the trust instrument is uh, revocated. But for will revocation, um, it needs intent plus physical act, something like tearing up, burning, destroying, and things like that, right? So um, we have to figure out whether this 2014 attempt at revocation was a valid revocation, right? So she deleted. So we go to the physical part, deleted, plus tore up one copy, right? Uh, Intent. I guess this is easily proven by the circumstances at the time. She married John, and because of that, she wanted to prepare a new will. And because of that, she deleted the old document from her computer and tore up one copy. So the situation proves that she wanted to, she got married again. And because she got married, she wanted to draft a new will, and therefore she tore up the old copy. So intent element, I would say, is satisfied. Now, there's an issue here because the there's a part that says Mary forgot about the other copy in her safe deposit box, right? So she had two copies, and one copy she forgot. But because her intent is met, and the physical act of tearing up one copy satisfies both elements, I would obviously talk about this because this is an issue here in this fact pattern. But I would still argue that even though she forgot about the copy in her safe deposit box, because she satisfied both the intent element followed by a physical act, I would say that the 2014 will revocation was also valid. So this was valid. Right. So when she revocated, with her revocation, she wrote on a corporate stationery with her business logo emblazoned on it, and Mary wrote, I leave John my gamma stock. My delta stock I leave to Bob. Amy is to get the house. Mary signed the document. She neither dated the document nor designated a recipient for her remaining property. Okay, so here, after she revoked the previous will, she drew up a will, and because this was not typed, it was handwritten. We're going to have to get into what is called a holographic will, right? And we covered this many times already. And in a holographic will, first you need the intent. And second, it needs to be handwritten, signed, right? And most importantly, the material terms must also be handwritten. So here, on her corporate stationery with her business logo emblazoned on it, she wrote, I leave John my gamma stock, my delta stock, I leave to Bob, Amy to get to the house. She wrote that. She even signed the document. She, even though she didn't date the document nor designated a recipient, the situation totally proves that there was intent for her to create a will, right? Now, she wrote here the facts. tell us that instead of typing she wrote this, I leave John my gamma stock parked. So this is also satisfied. Now, um, what is she leaving to who? Those are the material terms that also needs to be handwritten. And again, I leave John my gamma stock, which was written, my delta stock written, handwritten. I leave to Bob, Amy is to get the house, was all written. So this 2014 holographic will is valid because it satisfies all of these elements, right? So in 2000, actually, before we get to 2015, the facts tell us that she didn't date the document nor designated a recipient for her remaining property. So we have to kind of talk about that because that's an issue. Now, I would write that for the no date issue, holographic wills do not require dates, right? And as for the remaining property, is going to go through intestate succession, right? Meaning, if the spouse has no kids, the spouse gets everything in California. If the spouse is left with one children, um, the spouse gets one half, the children gets the other half. If there are more than two children, spouse gets one third, each children gets one third, and so forth, right? So we're gonna talk about how this is gonna go through intestate succession. Succession. Okay, so in 2015, Mary sold her Delta stock and used the proceeds to buy Tango stock. Okay, so according to that 2014 will, John was going to get Gamma stock, right? Bob was going to get Delta stock. And what does Amy get? Amy gets the house. So the fact that Mary sold her Delta stock and used the proceeds to buy Tango stock triggers a concept called extinction by redemption, right? Because what happened is that um, Mary sold uh, her Delta stock and bought Tango stock in 2015. And she died in 2016, right? So she willed the Delta stock to Bob, but in 2016, this Delta stock was no longer existing. So when this happens, um, this is called extinction by redemption, meaning since Delta stock was not existing at the time that uh, Mary died, then Bob doesn't get anything. However, there is an there is a exception, which is when a stock is sold, and with that uh, um, money, another stock is purchased. The stock buying and selling, replacing with another stock, would be one of the exceptions for extinction by redemption. So, because of this exception, normally Bob, because Delta stock was not around uh, wasn't supposed to get anything because when Mary died, this Delta stock was no longer uh, there. But because of this exceptions to the extinction by redemption theory, which allows Bob to trace the amount that um, to trace uh, Delta stock, and since this was sold, and with that money, it was they bought Tango stock. That means that Bob is allowed to trace and get this Tango stock, and that would be the exceptions to this extinction by redemption clause or rule, right? So, did we answer all the questions here? Yeah, I think so. The main thing here was, again, they wanted you to know what's required to have a valid attested will. Then they wanted you to, go through all this capacity issue, formality issue, right? And then they wanted you to understand and tell them what a valid revocation is like. And we explained how that was intent plus physical act, like tearing up, burning, and all that. Um, and then there was like a sub issue in which Mary had two copies but forgot to tear up one. But since these elements are satisfied, we said that that is not going to be an issue. Then the question jumped on to holographic will. And since holographic will is easier than attested will because it just has like two or three elements, um, we just had to prove that there was intent, make sure that it was handwritten and signed, and also the material terms had to be handwritten, right? But this holographic will didn't have a date. But since date is not a requirement for a holographic will, we said that that is not going to be an issue, right? Um, and then, let's see, we talked about the remaining assets that weren't included in this holographic will, but we concluded concluded that that was going to be distributed through intestate succession. And we talked about how, lastly, um, we're going to have to talk about the $200,000, right, in cash. That's the part we forgot. And we kind of went over intestate succession, but um, to divide this right here, we're going to have to figure out that John is the husband, right? And Amy and Bob were the children of Mary. So John would get, because there are two kids, would get one third. Amy would get one third, and Bob is going to get one third, right? Um, if there were just one child, uh, John would get half, and the other child would get half. But since Amy and Bob, according to the facts here, it says Mary was a widow with two adult children, Amy and Bob. But since she married John in 2014, through intestate succession, this $200,000, one third of it will end up in John's hands, one third of it will end up in Amy's hands, and the other third will end up with Bob. So that wasn't too bad. I mean, we had worse problems before this. Like both of them that we did prior to this question was very difficult, but I feel like this was pretty straightforward. Um, this is more of a modern one. This is from February of 2017. I feel like more the modern bar essays tend to be easier. Maybe that's just me, but compared to like the ones from like 2012, I mean, I would prefer to have this all day over them. So again, I hope that that was a helpful video for you, and that you will benefit from watching another person struggle trying to go through this issue spotting drill and trying to go over all the elements while doing that, which is always difficult. But with practice, I feel like it's becoming second nature. Once in a while, I blank out and I just can't remember that fourth element or fifth element. But if that happens, I will probably, if this was like a real test setting, I would improvise because I don't have time to stop for like the next 15 minutes trying to think about what that last element was. But I think the wise thing to do in those situations is to improvise, use an element that sounds right, but you don't want to make it so awkward, but make it fluid and just keep writing to finish the essay. So, with that, I hope that, again, this video was helpful for you, and I'll see you in the next video.